Well, if it's okay with you, I think we'll go ahead and get started. We've got several participants online this evening. All right.
Okay.
All right. So good evening, everyone. On behalf of the State Bar of Montana and the Law Related Education Committee, I'd like to welcome you all to another session of Citizens Law School. The purpose of these sessions is to provide opportunities for citizens to learn more about a specific area of the law, as well as the legal system in Montana. I'm Helen Thigpen. I'm a Deputy Commissioner in the Office of the Commissioner of Higher Education, which is the administrative head of the Montana University System and the state's public colleges and universities. I'm also an attorney. It's my pleasure to welcome tonight's speaker, Judge Menahan. We're so grateful that you're able to join us this evening, Judge. For those of you who may not know, Judge Menahan is a district court judge in Montana's 1st Judicial District. Judge Menahan was elected to the bench in 2012 and re-elected in 2018. He is the chair of the Montana Judicial Standards Commission, and he previously served as a legislator in the Montana House of Representatives, both in 2009 and again in 2011. He also worked as a prosecutor with the Lewis and Clark County Attorney's Office for 18 years. Judge Menahan, on behalf of the bar and everyone here this evening, I'd like to thank you for taking the time after work to join us and for sharing some thoughts about the role of the courts and what your day is like as a judge. Okay, and so I will turn it over to you.
Thank you very much. First of all, is the light behind me distracting? I should have moved the lamp and put it in front here.
Not to me, it looks fine on my end.
Okay, all right. And you can hear me okay?
Yes.
So I would just say that I do not want to drone on for an hour. Attorneys interrupt me all the time and I'm used to that. So I would just encourage the panelists to stop me at any point and ask a question. I think that's the entire purpose of this seminar, is to, I think, try to make the courts a little more accessible to the public. And so if people have questions, I encourage them to stop things and ask. Essentially, the outline of my discussion tonight, I want to talk about Montana courts specifically, and the different types of courts and generally, and then to talk about what I do as a district court judge. So I'll start by saying a little introduction just about myself. So I was born in Helena. I grew up in Anaconda, went to the University of Montana and the University of Montana School of Law. So when I grew up, I didn't have any attorneys in my family. I didn't have really a very good idea of what it was that lawyers do for a living. And so I was the first person in the family to go to law school and become an attorney. And when I went to law school, I didn't really have a very good idea what lawyers did. I studied forestry at the University of Montana. I took a few years off and worked. And then I went back to law school. So I was 30 when I graduated. And I didn't have a very good understanding where I'd kind of wind up working, and found that I really liked criminal law. I worked as a deputy county attorney for 18 years for the Lewis and Clark County Attorney's Office before I ran for judge. I'll just tell you a little bit about the courts in Montana. So the courts in Montana have authority pursuant to Montana's constitution. Montana adopted a constitution initially when we became a state in 1889, but then that was revamped in 1972, 50 years ago. And so Article 7 of the Montana Constitution essentially establishes the authority for courts to operate under Montana's system of government. And so that Article 7 says that the judicial power of the state is vested in one Supreme Court, district courts, justice courts, and other courts as provided by law. And so it says further that the Supreme Court, the members shall have 8-year terms. They'll run on a statewide basis. And the Supreme Court has appellate jurisdiction over all cases that arise from the lower courts, and that they have original jurisdiction on writs of habeas corpus. That's an old term. It means have the body. Essentially, it's a provision that says people can't be detained unless there's some authority of a court somewhere to detain them. So if somebody feels that they're detained unlawfully, they can file a petition for a writ of habeas corpus from the Supreme Court. So the Supreme Court has supervisory control over all the courts in Montana. And pursuant to the Montana Constitution, they have a Chief Justice and four justices. In the Constitution, it says the legislature may increase that number. So instead of having 5 justices of the Supreme Court, as the Constitution provides, we actually have 7 because the legislature some years ago increased the number of the Supreme Court from 5 to 7. So district court judges are elected on a 6-year term as opposed to 8-year term by the Supreme Court. And the district courts have original jurisdiction in felony criminal cases, all civil matters at law and in equity. That's what the Constitution provides. In practice, this is what we have. And I've written this down. So we have jurisdiction in felony criminal cases, civil matters, and by civil matters, that can include a lot of things, but essentially if somebody's suing somebody for money damages, anything more than $12,000 takes it out of small claims court, puts it into district court. We have jurisdiction in adoptions, guardianships and conservatorships, juvenile cases, so that's youth court. If a youth commits crime, they're brought into youth court. Child abuse and neglect proceedings, probate cases, those are cases dealing with wills and estates of people. Domestic relations, that means family law cases. So any case in which somebody gets a divorce, there's a parenting plan issue, something of that nature, family law cases, those come to district court judges. Paternity cases, commitment with a person with a mental illness. So involuntary commitments to the Montana State Hospital. All of those cases arise out of the state's district court judges. And then search warrants, investigative subpoenas. So you'd be surprised at how often law enforcement officers come to district court judges to obtain investigative subpoenas and search warrants at all hours of the night, all weeks of the year, all days of the year. We're available to sign search warrants. And then recently, we have treatment courts, family treatment courts, drug treatment courts that district court judges have authority over. Also, we have appellate jurisdiction over courts of limited jurisdiction. So what that means is there are a number of courts in Montana, justice courts and city or municipal courts. There are courts of record, and those courts sometimes have cases in which a matter is appealed to the district court, and we essentially act as an appellate court over the courts of limited jurisdiction. For example, in the city of Helena, our municipal court and our justices of the peace are courts of record. So if someone's convicted of a misdemeanor DUI or a partner family member assault or a traffic offense, or they have a landlord-tenant dispute, and if any of the parties are unhappy with the result, they can appeal those cases to district court, and we act as a court of review. In smaller counties in Montana, where the justice courts and the municipal courts are not courts of record, the Montana Constitution guarantees that the rights of the individuals have a right to a trial de novo. It's a Latin term. It means, I think, from the beginning or nothing. And so if you're convicted of a misdemeanor DUI, maybe in Lewistown, Montana, Fergus County, justice of the peace, I think that's not a court of record. You can appeal that to the district court, and then you get a trial anew in the district court. It's a unique provision of the Montana Constitution that you don't see in too many other states. So the qualifications to be a district court judge or a Supreme Court judge are that you're licensed in Montana to practice law, and you've practiced law for 5 years. And that qualification, those eligibility requirements are set forth in Montana's Constitution, and they've been the same for the last 50 years. So justices of the peace are elected to 4-year terms. That's in the Montana Constitution. It's interesting, the Constitution provides that each county shall have at least one justice of the peace. And so it says that the qualifications of the justice of the peace are provided by law. So the legislature establishes their qualifications. You don't have to be an attorney to be a justice of the peace. And so they have original jurisdiction in misdemeanor criminal cases, landlord-tenant cases, small claims cases, things of that nature. So we're state courts, and a lot of times people ask me questions about matters that are pending in front of the United States Supreme Court, federal district courts in Montana, the Ninth Circuit Court of Appeal. And so sometimes, a lot of times people, my family members, others, we start talking about the different courts in Montana, and they haven't always made the distinction between the difference between federal court and state courts. So the United States Constitution, Article 3, establishes what lawyers refer to as Article 3 court. So it establishes the United States Supreme Court, and it establishes federal district court judges. So in Montana, you've got Brian Morris, Dana Christensen, Sam Haddon. They are district court, Don Malloy. They're a handful of district court judges in Montana. And they have jurisdiction over conflicts between people that are not residents of Montana and corporations that may not be residents of Montana. They have jurisdiction over those matters. They have jurisdiction over crimes that take place on Indian reservations in the state, and also federal areas. So somebody commits crime in Glacier Park, that crime is going to be prosecuted in the federal courts. And so there's an intermediate appellate court in the federal system that we don't have in Montana, and that's called the Court of Appeals. Every state in the country belongs to a particular circuit. Montana's circuit is the Ninth Circuit Court of Appeals. So any decision that's made by a district court judge in the federal system can be appealed, and that appeal goes to the intermediate appellate court first, and then it can be appealed to the United States Supreme Court. So kind of interesting. When Carla Gray was Chief Justice of the Montana Supreme Court, there was a pretty big backlog at the court level at the Montana State Supreme Court. And there was a proposal back then to adopt a model that many other states have and establish an intermediate appellate court in the state of Montana. So there was a bill at the legislature back in the 1990s or so to establish an intermediate appellate court. The legislature rejected that. In the last 20 years or so, the backlog of cases at the Montana Supreme Court has been significantly reduced, and nobody's really asking that there be an intermediate appellate court. So I think one of the things that people were interested in are what is a day in the life of a district court judge like? So today is Wednesday. On every Wednesday morning, I have what's called criminal law in motion. And so at that time setting, every Wednesday at 9 o'clock, I do all of my criminal initial appearances, arraignments, initial appearances on petitions to revoke sentences, admit deny hearings on petitions to revoke, evidentiary hearings on petitions to revoke, changes of plea, sentencing hearings, bond hearings. I'm trying to think of all the things, but I had a pretty busy morning this morning. So I was in court essentially from 9 to 12. I took a break around 11:10 just to get out of the courtroom for a few minutes and give everybody a break, and then went until noon. So I heard a number of bond hearings today. I had a young man who's charged with attempted deliberate homicide, and he asked that his bond be reduced. So we had a bond hearing on that. We had another person who's charged with sexual intercourse without consent. We had a bond hearing in that matter. I had a number of cases in which people changed their pleas, some of which we proceeded to sentencing today. In other cases, we ordered the Montana Department of Corrections, Adult Probation and Parole to conduct a pre-sentence investigation and then set this sentencing hearing out in a few weeks. We were not in court, of course, over the noon hour. And then at 1 o'clock, I started doing what I call my civil law in motion. So I had some name changes, uncontested dissolutions. So a dissolution to somebody filed a petition to dissolve their marriage. Interesting case I had today. Woman was married after knowing somebody for 1 day, and they've been married since 2000, I think 13 it was, and never got around to getting a divorce, even though they haven't been together since they got married. And so that was an uncontested matter that I just took me a few minutes. I do all the probate cases, wills and estates cases. So I had a hearing to close the account of an estate. So the attorney came in with the daughter of the deceased, and we put on the record all the evidence that you need in order to close an estate. She was the personal representative, and she testified that she sold the house, divided the proceeds between she and her 2 brothers. She didn't take any fees related to her, all the accounting that she did, paid all the bills for the estate. Vast majority of those cases wind up being fairly not controversial. And then in the afternoon, I had an involuntary commitment to the Montana State Hospital. And then I also had my youth in need of care dependency neglect type cases, the child abuse and neglect. And I had my law in motion on that case today beginning at 3. And those are cases in which the Department of Public Health and Human Services, Child and Family Services Division, Child Protective Services workers remove a child from a home of parents who are alleged to be abusing or neglecting their children. And so those cases get to be pretty complicated because you have attorneys who represent the children, if they're old enough to reason and have a relationship with the lawyer. The parents each have their attorney. There's an attorney representing the department. We have court-appointed special advocates who come into court who are also looking out for the best interests of the children. So those get to be quite onerous, complicated, because of all the different parties involved and all the attorneys involved. In some cases, you might have 3 or 4 children, or 5, as I have in a couple cases currently, and each of them have a separate father. So then you have an attorney for the mom, attorney for each of the 5 dads, attorney for all the kids. Generally, there's just one attorney. So they get to be pretty onerous, pretty complicated, and can involve a lot of the court's time. I'd encourage anybody to ask any questions about any of these matters. I think I'll just talk a little bit about the district court judges. So Montana has, I think, 22 judicial districts. Some of those judicial districts, like the 8th Judicial District, is Cascade County, and it only includes Cascade County. I think the 18th Judicial District, Gallatin County, is just Gallatin County, and Yellowstone County is, I think it's the 13th Judicial District. They're just Yellowstone County. In some areas like Missoula County, they're the 4th Judicial District. They include Missoula County and Mineral County. So judges from Missoula also go up to Superior regularly to have court. In Lewis and Clark County, where I work, we're in the 1st Judicial District. That includes Lewis and Clark and Broadwater County. And so one of us 4 judges in Helena go down to Townsend every Friday. So somebody's holding court down on Friday every week. In some judges, in some judicial districts, for example, the 5th Judicial District, which is right next door to Lewis and Clark, includes Jefferson County, so Boulder's county seat, Madison County, Virginia City, which is the county seat, Beaverhead County, Dillon, all comprises one judicial district. So the judge in that case, Luke Berger, divides his time between Virginia City, Boulder, and Dillon. And so he's regularly making appearances. He's got criminal law in one county in one day of the week, another county the next, and another county, and so on. The largest judicial district in Montana is in eastern Montana that includes, I think, Fallon County, Custer County, Rosebud County. It's a Treasure or Prairie County. It includes, I think, a total of 7 different counties. And there are 2 district court judges that divide those 4 counties or 7 counties between the 3 judges. So they spend what they describe as windshield time driving between all their different courts. There are a total, I think, of 54 or 56 district court judges in the state of Montana. So there aren't very many of us. If you think about it, there are 100 members of the House of Representatives, 50 senators in Montana. So there are very few members of the judicial branch. We're the smallest branch in the state government. We also have the smallest budget, I believe. So we don't take a lot of resources. We also don't have anybody who enforces our court orders, interestingly. Some of you may have heard the story about, I think it was the Yalta Conference after World War II, when Winston Churchill, Franklin Roosevelt, and Joseph Stalin were meeting to try to plan for the aftermath of the defeat of the Axis powers. And I think Roosevelt and Churchill were talking about Italy, and they were talking about the Catholic Church and temporal power and that kind of thing. And Joseph Stalin made this quip asking how many divisions the Pope had. Well, the point of that was that Joseph Stalin wasn't going to recognize the authority of the Vicar of Rome because power, in his view, came out of the muzzle of a gun. So courts in Montana, courts in the United States don't have an enforcement arm. Really, the only power that the court has to enforce its orders is its contempt powers, which is very seldom used to hold somebody in contempt for not following a court order. In our constitutional democracy, people generally follow the orders of courts. Again, okay, great question. Because what I'm going to do next, I'm going to talk about the rule of law and go into that a little bit.
Oh, just a quick question for you, Judge Menahan. Just curious if you could talk a little bit about the process for how cases are assigned in the first judicial district, and maybe just in general, how certain cases come to you versus a different judge in your district.
Good question. So in all courts in Montana, so if you have somebody like Luke Berger, who's the only judge in the district, any case it files gets assigned to him. But in those judicial districts in which there are more than one judge, we have a case management system. It's a computer program that essentially is a court management system. So all the documents that are filed in court are scanned, and then they're available electronically to the judge. So that case management system is called Full Court. And when a case is filed, it's filed in the clerk's office, the clerk of district court. Each county has one. And the cases are assigned to us on a random basis. So if somebody wants to judge shop, they can't really do it. They file the case and it gets assigned randomly by a computer. Sometimes the computer, I think, makes mistakes. Either the computer program doesn't like me, because in the last 2 days, I've received 5 petitions for restraining orders. And when I got the 5th one, I said to my judicial assistant, really? And she said, oh yeah, the Full Court program seems to be making a mistake. You're getting all of them. But they tell me that over the span of 12 months, it all evens out, although sometimes I question why. But anyway, those cases are assigned to us judges on a random basis. Montana has a very interesting provision in its law, and it's called the substitution rule. It's something that's unique to Montana, and it's unique to our history. During the Battle of Butte, when F. Augustus Heinze had essentially bribed a couple of district court judges in Butte, one whose name was Thomas Hardy, who had a beard like that came down, looked like Luke Berger, in fact, beard that came way down to his chest, had used a law that was never used in Montana up until that time. It's called the Apex Law. So if you lived in West Virginia or Pennsylvania and you discovered a seam of coal that apexed on your property, on your farmer's field, you could follow that seam of coal no matter where it went, because mostly it went under your land and not that of your neighbors. But if it did, you could follow it all the way down. Well, in a highly fractured environment, such as the Butte Hill, that had been fractured by fault lines over millennia, it was impossible to follow those seams of copper to their source, because you'd follow them for 100 yards, you'd reach a dead end, and then you'd find that that seam was picked up 100 yards to the east or west or north or up or down. So F. Augustus Heinze bribed Thomas Hardy, who essentially ruled that F. Augustus Heinze had all the seams of copper under the Butte Hill apexed on F. Augustus Heinze's property. And so the Anaconda Company went to the legislature. I think William Andrews or Clark said at the time, how could he fight a judge who had larceny in his heart and egg in his beard? And so the legislature passed a law and said that for a small fee, anybody who did not want to have the judge that was assigned to their case stay on their case, they could pay a small fee, and that judge would have to assign it to somebody else. So if anybody draws me as a judge and they don't want me, they can file a motion to substitute, and I have to give it to another judge. It doesn't happen very much. Sometimes judges feel that attorneys abuse that a bit, that they're judge shopping, but by and large, I think it's fair, because it gives both the public the ability to say, they don't think somebody's going to be impartial. Maybe they have a gut feeling. For whatever reason, no reason at all, they can substitute that person. Doesn't happen. It's not used very much, but it happens.
Thank you.
So it's interesting. I've been asked to speak recently on the rule of law. And it was part of the, I think the request to speak to this group was to discuss the rule of law. And then I'm speaking to a group at St. Mary's Church on Sunday this week here in Helena, because they wanted to hear from a district court judge and they wanted to hear on the rule of law. And I was thinking, that's a term that I've heard a lot, but I never hear it in court, and I never heard it in law school. And I think because of perhaps larger political movements that are happening in this state and country, the rule of law is getting a lot of attention. And so I think people are looking perhaps for courts to explain what exactly does that mean. So I've gone to a couple sources, mainly Google, Wikipedia. So the rule of law, essentially, it says it's a political philosophy that all citizens and institutions within a country, state, or community are accountable to the same laws, including lawmakers and leaders. So the rule of law essentially says that no one is above the law. And I think that principle came from England, when English nobility were upset with the tyrannical nature of their monarchs, and essentially forced concessions upon King John to adopt they adopted the Magna Carta. They established a constitution which has never been written in England, but it evidently is still the Constitution, and they all abide by it. But in England, the rule of law essentially said that no person was above the law. And so I think that that may not have always applied to the monarch, but that's the idea. In the United States, so in England, they have essentially what's called, I think referred to as a constitutional democracy, or excuse me, a constitutional monarchy, because their monarch is their titular head of their country. They have a parliamentary system of government, representative system of government, and a constitution, where we have a constitutional democracy or a constitutional republic. So a democracy is essentially a nation in which you have the rule of the majority. But in our system of government, I think what you would describe this as is a democratic republic or a constitutional democracy. And so that constitutional democracy is sometimes called a liberal democracy, and it's liberal in the small L. It doesn't mean, it has nothing to do with today's political factions, but essentially a liberal democracy is a democracy in which the majority elect their leaders. A republic is a type of government in which power emanates from the people, not from a monarch or an autocratic dictator. And in that republic, if you have a democratically elected type of government, it's constrained. The majority is constrained. Essentially, the founders of our country were concerned about mob rule. And so we have a liberal democracy in which we have a constitution that protects the rights of the minority. And so you might look at a country like Pakistan and say Pakistan's a democracy because they have leaders which are elected by their people, but they don't have rights that protect the minority. There's no freedom of religion in Pakistan. There's not a freedom of the press. There aren't the other freedoms that we associate with a democracy that we have in the United States. So I was looking up that rule of law, according to a number of folks, both in Britain and the United States, have essentially said that for there to be a rule of law, you have to have a government that is bound and ruled by laws. And so that's one principle. Another one is that people must be able to understand the law and comply with it. And the law should apply equally to everybody. It should be stable or provide stability. Law should be reasonably stable in order to facilitate planning and coordinated action over time. I mean, one of the things that surprised me about learning law, I went to the University of Montana School of Law, and I didn't have a very good understanding, as I've said, about what the law entailed or how it affects our lives. But what has struck me, it struck me then, and it continues to do so, is that the law is really a conservative force. I mean, people kind of look at the law and say it's an agent of progressive change because you look to see how our definition of rights under the Bill of Rights has expanded over time. But that's done in a very slow, piecemeal fashion. Courts really build on rulings on an incremental basis. There's rarely, I think, a really big movement in law. When that happens, it's noticeable. But I think that law, for the most part, when I look at what I'm doing in civil cases, even in probate cases and others, the court's function is to resolve conflicts in our society. So the conflicts we see are where people are trying to enforce their contracts. They're trying to enforce the rights related to their personal affairs and their businesses. And so people are making business decisions, or they're making decisions related to their personal lives based upon their belief that the law will support them in whatever that activity is, personal or business. And they rely upon that stability to conduct their own affairs. And and they know that the law won't be subjected to the arbitrary whims of a judge who may disagree with the law in some fashion, that they have a reasonable ability to predict what the outcome of a dispute will be based upon that precedent. There is a very strong precedent in the law. It's called stare decisis. It's a Latin term, and it essentially means let the decision stand. And so district court judges like myself don't often have cases where we're making some decision that is a monumental shift from what the law is. We're relying upon case law, decisions of the Montana Supreme Court, statutes that have been adopted by the legislature, and then applying that to the facts in any particular case. You know, sometimes we get it wrong. All of our decisions can be appealed to the Montana Supreme Court. Most of the time, Supreme Court affirms district court judges, and most of the time they do so unanimously. I think about 80% of the decisions that are issued by the Montana Supreme Court are unanimous decisions in which all of them agree. So, yeah, I have a couple things here. It says the founders of the US Constitution were concerned that without some limitations, pure democracy could simply devolve into mob rule. It's interesting, you know, there have been a number of decisions recently where the Montana District Court judges have struck down bills that were adopted by the legislature in recent years. And I served in the legislature myself. I have a great deal of respect for folks who serve in the legislature. My father served in the legislature from Anaconda for 30 years. In my second session, I think I said to him at one point, "Dad, how could you do this?" As if something wrong with him. But he thrived in that atmosphere. He was, you know, working on behalf of the people in his hometown of Anaconda that he cared greatly about. And he really enjoyed that process over a long period of time. The legislatures sometimes pass laws that come before courts on a constitutional challenge. And so judges sometimes look to see what the legislature did and look to the Montana Constitution or the United States Constitution to see if they comport with each other. The Constitution, both federal and state, gives the judicial branch the power to review legislation that's passed by the legislative branch, signed by the executive branch. And so I'm just reading a quote here that was in a recent case, and it says, Montana's Constitution serves as a limitation on the legislature, not a grant of power. So I think that that's really interesting, that the way the Supreme Court interprets the Montana Constitution is that the powers of each branches of government are not unlimited. Their powers are only exist to the extent that the Constitution provides. It says exercise of the legislative power to undermine the constitutional power of the other branches of government is going to be met with a great deal of review. There's a real famous case in the United States courts. It's called Marbury versus Madison. It's an 1803 case. And essentially, the way that the Montana Supreme Court has looked at that, they say the courts and the legislature derive their respective power from the same authority, the Montana Constitution. The Constitution defines the powers of each and imposes limitations upon those powers. Absent language to the contrary, a direct power conferred upon one necessarily excludes the existence of such power in the other. This fundamental premise lies at the very root of the constitutional system of government. So, one thing that I would encourage the class, apart from asking a few more questions, is when you see a decision that a district court judge has made, or a Supreme Court, the Montana Supreme Court has made. And if there's criticism, look to see, is the criticism a personal attack against the judge, or is it a discussion of what the court did? Because I always think it's easier to make a personal attack against the judge than it is to actually address the merits of the decision. Because judges are often making decisions, they're not concerned whether or not the policy is a good or bad policy. They're looking at how that policy affects the other rights that are enumerated in the Constitution. So, thank you. Question.
Okay, one question. I actually have a couple questions, but the first question is, you are an elected district court judge, Judge Menahan. Do you have any thoughts on whether judges should continue to be elected, district court judges, or whether they should be appointed? If that's something that
that's a great question.
Feel like you can address.
I think that most states, I think about 38, I'm not sure the number, but I think in about 38 states, judges are elected. In the remaining states, they're appointed. Carla Gray, who was my neighbor for many years, and I knew her a long time, she was a proponent that judges should be appointed rather than elected. Mm-hmm. And so that doesn't break down simply on it's not like a political question. It doesn't break neatly on lines one way or the other. In some states where judges are appointed, they go through a pretty in-depth review process, and then they have to stand for election during the next election. And so that's not what we have here. I think what the founders or the framers of the Montana Constitution wanted was that judges would be elected because they're more accessible to the people, and they're more accountable. I have to say, I think that voters, we served our constituents who elect us. The vast majority of people in Montana know who's running for judge in their community. If they don't, they go and they talk to attorneys, or they talk to other people who know. So I think that typically, we live in a small state. We only have 1 million people. By and large, I think the judges who are elected are very much representative of the communities in which they serve. So it's a trade-off one way or the other. We haven't had a lot of hotly contested district court judge elections in Montana's history. In recent years, there have been more spirited campaigns for the state Supreme Court, but those are kind of a different animal than what you have for your local district court judges. So,
yeah. Thank you. The next quick question is, if you could wave a magic wand and ensure that each citizen of Montana knew one thing about the courts, or your role in the judiciary, or the role of the courts in general, what would that be? What would you want every citizen in the state to know?
I think that's a good question. I mean, one of the things that we see a lot of people that are now appearing in court that are not represented by attorneys. And so those people appear pro se. It means on behalf of yourself. And so a lot of folks who come to court have a problem, and they kind of remind me of Kenan Thompson, the comedian on Saturday Night Live, who used to play kind of a crank who would just say, here's a problem, fix it. And sometimes I think that people come to court and they want the court to fix their problem. And maybe there is a remedy for whatever problem that they have. But judges are considered neutral. Chief Justice of the Supreme Court, John Roberts, said, judges are umpires, we're referees. And that's, I know people have lots of opinions about the Supreme Court where they may disagree with that, but I think that is a pretty accurate description. In our system, of justice, the judge is supposed to be a neutral party, and we have what's considered an adversarial system of justice that anticipates that each side is going to make their arguments to the court, and then the court hears all the evidence, makes factual determinations based upon the evidence, and then applies the law to those facts. And a lot of people want to come to court. They think the judge should be able to hear them. I should be able to get a fair shot representing myself if I show up in court. But they don't realize that we have rules of evidence that dictates to us what can be admissible at court. We also have to apply the law. And so a lot of times people come to court with a problem, but they don't understand that we may not have authority to do what it is that they want. Or, you know, there's certain procedural safeguards where the other side has to have an opportunity to come in and present their case. And so I don't know if that's an answer to this question, because it's not just one thing, but courts can't solve all problems. And our system of justice is sort of limited in that way. I find myself acting in a role that I think is unusual for a district court judge when I get a lot of people that aren't represented by counsel, and I play the role of mediator a little bit. You know, they come to court and I say, I am not the author of your lives. I don't know your lives. I don't know your children. Yet you're coming to court and you want me to make decisions related to your family. And so I wind up asking them all kinds of questions and try to get them to work with each other in order to work out, for example, a parenting plan that works for their busy schedules and what's in the best interest of their children. So our courts can't solve all the problems that people want to bring to us. There are other,
That's a great
there are
point.
other, you know, avenues for that, and that's, I think, why the bar tries to engage in programs like this. Okay, other questions?
Great. And last, let's see, I think I've got one in here. Last question that I have is, in your role as a judge, Judge Menahan, you know, you mentioned this, you're a member of the community, you're elected into this role, but you also are a member of our community. And just curious, what do you find is sort of the most challenging aspect of being a district court judge? And then also maybe what's the one thing that you really enjoy and why you've sought to do this as your profession?
You know, I didn't aspire to be a judge. Similar, you know, when I said that I didn't really know any attorneys. I grew up in Anaconda, so some of the attorneys, you know, they did a lot of work comp type related stuff, and it was back when the smelter was going strong and there were people getting in industrial accidents. I didn't really have a very good idea what lawyers did. One of the things that surprises me, and not surprises me, but it's just something that I've done for so long, is that you're, as a judge and really as an attorney, you're trying to solve conflicts with people. I was a prosecutor for 18 years. So in many instances, you have somebody with mental illness, chemical dependency, you know, dysfunction, and they're committing crimes. And then you're trying to address, you know, that person's individual problems so that they don't commit further crimes, and they address whatever it was that got them into trouble. You know, in some cases you have victims of crime. So you're trying to essentially obtain justice for a victim of a crime and also address the needs of the defendant in order to keep them from getting into trouble again. As a judge, you're in the role of resolving conflict. So, I mean, all day long, I had to make decisions. Do I commit this person to the Montana State Hospital or not? And the consequences, if I didn't, might be pretty dire. You know, do I reduce the bond of somebody who's charged with a drive-by shooting which shot 2 people? You know, do I send somebody to the custody of the Department of Corrections where they'll get treatment? Or do I put them out in the community where they may not? And so every case that comes in front of you, you're really having to make decisions where there might be maybe winners and losers. I mean, I did see it. There was one comment and it said procedure should not derail essentially justice. I mean, our court system is really designed to resolve conflicts in a way that's fair and that's stable and that's uniform over time. And I agree that, we don't throw people out on procedural grounds. Decisions have to be made on the merits, or we try to be. I get a lot of cases where one side is pro se, the other side is represented by an attorney. And so the pro se litigant may not respond to some legal thing. And then the other side, the lawyer might file a motion to get a default judgment against them and then win on this, procedural ground. And so those kind of cases are really discouraged. I just tell parties, I'm denying your motion to dismiss. We're going to decide this case on the merits. I think judges are always trying to achieve, we want to treat everybody same. We want to treat people fairly. Not everybody's happy with our decision. If you think about it, every time we make a decision based upon the facts and law in the case, one party could be leaving the courtroom dissatisfied. So I think that, I'll just use this as an example. In criminal cases, when I sentence somebody, I'll tell the prosecutor, I'll tell the defendant, when I'm imposing a sentence here, I'm trying to impose a sentence that's similar to a similarly situated defendant, a defendant who has similar criminal history that you have, and a similar crime. Today I had a young woman, she's younger than 25 years old. It was her third felony. This was a burglary in which they stole a handgun from a cabin. She was involved in a case a few years ago where her associates, one of whom in a drug deal punched somebody. The gun discharged and killed the father of her child. This was second felony she received since essentially obstructing justice in that case back in 2015. So I'm heartbreakingly sad when she's crying in front of me today when I'm sentencing her, but I'm saying you need to be committed to the custody of the Department of Corrections so that you can go to the Passages program in Billings and get treatment. And when I explain the reasoning for it, she might disagree with that, but I know that what I'm doing is consistent with what I've done in cases with similar defendants. Long day.
Well, yeah, it sounds like a really long day. I want to be respectful of everyone's time, and especially your time, Judge Menahan. We're coming up on our hour here, and I just want to really thank you for taking the time after a long day to participate in this event. And I want to let everybody know here that we do have we have several more actually sessions coming up next week. On October 26th, there'll be a session on small business and employment law, which I think might be of particular interest to some folks out there. We have a really great attorney in Helena, whose name is Amy Christensen, who will be providing that update. She specializes in employment law and helping small businesses. So I would encourage anybody here that's interested in that to join in next week, and just really so appreciate everyone for joining. And we do have, I don't know if we might have 2 minutes here.
There's another question. Yeah. So I see a question that says, do judges across Montana try to give the same sentences for same crimes? And I'd say yes. Many crimes have like a mandatory sentence that's uniformly applied. For example, if you get a felony DUI, everybody gets the same sentence. But to the extent that we give sentences same, it's up to the individual judge, but I think judges try to be uniform. One thing, I have a background as a prosecutor, so I knew criminal law. So if a prosecutor comes to me and says, this is a crime of the century, I want you to, throw the book at this person, I don't, because they're asking me to do something that's so out of bounds of what has been done in similar cases. I sometimes think that civil judges who have, by that I mean a lawyer with a civil background without criminal background, is at a distinct disadvantage coming onto the bench because they may not know what is typical for a particular sentence. It used to be the Montana Department of Corrections, Adult Probation and Parole. Probation officers would make sentence recommendations in criminal cases so that they would provide that uniformity across the state. I thought that was a very good thing. I liked it. But under recent administration, they stopped doing that. So probation officers do not give their opinion as to what a sentence should be. And I think that that should be changed. But that's a decision for the Department of Corrections and the executive branch.
Excellent. Well,
Good
right on
question.
time. Yeah, great question.
All right. Well, I do appreciate that everybody who's participating. I think that to the extent that people know more about Montana courts, I think it alleviates some of the confusion, concern, and sometimes outright distrust or displeasure with the court. So thank you all for participating.
Absolutely. Yeah. Thank you all. Thank you so much. And hopefully we'll see some of you next week. Appreciate it. Thank you, Judge Menahan.
All right. Good night.
Thank you.